The webinar will begin in 1 minute. Welcome, everyone. We are pleased that you have joined us for today's webinar titled Trust as Beneficiary of NQDA. The webinar will last approximately 20 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter will be Linus Sugis. Linus is the president of Advanced Underwriting Consultants. He and his team answer tax and technical questions posed by producers every day. Linus also spent 14 years working in the home office of a life insurance company in various roles. He also started, ran, and sold an estate planning law practice in the Nashville area. Linus will draw on his legal and life insurance experience during today's webinar, and here he is.
Thank you very much, Amber, and welcome everyone. I'm glad you've joined us today for the topic, Trust as Beneficiary of an NQDA. Before we get into that, let's decide what it is that we're going to cover next month. Your choices are hidden details in the new minimum distribution tables, a big mistake with a self-directed IRA, or free online resources to use in your own businesses. I'm going to go ahead and open the poll and ask you to go ahead and make a selection. The poll is open. I'll give you about 30 seconds. If you haven't yet voted and would like to, please do so. Give you just a couple seconds. We're going to go ahead and we're going to close the poll. And next month, we'll discuss hidden details in the new minimum distribution tables. Thanks for voting. The webinars are the first Wednesday of every month. They're at 11 a.m. Central. The next one will be on March 2nd. And if for whatever reason you're unable to attend, you can always get the recordings of these webinars on our YouTube channel. And so feel welcome to do that. Feel welcome to share the link with anyone that you feel like would get some value out of what it is that we cover. And this month, we're going to cover trust as beneficiary of a non-qualified annuity. And you know, the reason that we're covering it is that, you know, we at Advanced Underwriting Consultants get asked about this situation an awful lot. One of the questions that typically comes up is the life insurance or financial professional wants to know why in the world a client would choose to name a trust the beneficiary of a non-qualified annuity. We'll cover that in a little bit of detail. We'll talk about the stretch implications for an inherited non-qualified annuity. They're different from the stretch implications, perhaps, that would apply to inherited IRAs or inherited qualified plans. So we'll cover that in some detail. We'll talk about some of the tax uncertainties with regard to stretch and inherited IRAs. We'll give some advice about how to help clients make decisions in advance about whether or not to make a trust of the beneficiary. And we'll also talk about what things professional might look out for where a trust is already the beneficiary of an inherited NQDA, and how to deal with those circumstances and how best to advise a deceased client's family. So let's go ahead and get started. First of all, on talking about why a trust might be a beneficiary of a non-qualified annuity at all. And for me, thinking as both a life insurance guy and as a lawyer, it really comes down to control versus tax timing. Tax timing, you've got more flexibility with regard to tax timing for the beneficiaries if individuals are named as beneficiaries of a non-qualified annuity. But if your annuity owner wants to have better control, better protect family members after death, in a lot of cases, it makes sense for the annuity owner to name a trust as the beneficiary. And that's really what it comes down to. And when we get callers asking about that, that's what we tell them. For those who are really interested in control, who are worried about their beneficiary's abilities to handle money, having a trust as the beneficiary might be the right approach. Where taxes and the timing of income taxes are more important than anything else, usually it's individuals that will end up being the beneficiaries of a non-qualified annuity. And so let's talk for just a second before we leave here about the beneficiary designation itself. We can name a trust as beneficiary if we've got a trust that exists right now. In a lot of cases, clients will have living trusts, irrevocable trusts, or other kinds of trusts that they've already created that could be the beneficiary of a non-qualified annuity. By the way, naming a living trust as the beneficiary of a non-qualified annuity where you've got a married couple may not be the right approach. If we've got surviving spouse as a direct beneficiary, surviving spouse clearly has the ability to treat the inherited non-qualified annuity as her own. Where a living trust is the beneficiary, that result may not be attainable. We may be stuck with 5-year liquidation. We'll get into that in just a little bit more detail, but that's certainly something that ought to be thought about. When a client says the client wants the living trust to be the beneficiary, I think it's prudent for us to ask the next question and find out more about what it is that the clients have in mind, dig a little deeper. In any event, it's possible for right now trusts to be named beneficiaries of non-qualified annuities. It is also possible from a technical perspective, from a legal perspective, to have testamentary trusts named as beneficiaries of non-qualified annuity. What's a testamentary trust? It's a trust that doesn't exist today. It's a trust that will spring into existence at the account owner's death. A lot of times those trusts are springing trusts that arise out of a client's last will. They don't come into effect until somebody dies. In other cases, it can be a trust that is a subset of a client's living trust that comes into existence at the client's death. And from my perspective, it is perfectly acceptable to name a testamentary trust as the beneficiary. And in most cases, it's better than naming the client's estate as beneficiary, because if the testamentary trust is the beneficiary, in most cases, you can bypass the probate procedure in order to let the trust get the money. And that's a good thing for most of our clients, bypassing probate. So some carriers get a little bit funny about testamentary trusts. They want certain words, or they want certain kinds of conditions there. And so I tell you that to check with the carrier, but certainly it is possible from a technical perspective to name a testamentary trust as the beneficiary. So now that we've covered why a trust might be the beneficiary, let's talk about the stretch implications of naming the trust the beneficiary of an unqualified annuity. And we've pulled the language here from Code Section 72. And I apologize for pulling the tax code in, but it's kind of necessary in order to understand what's going on. And basically, Code Section 72S says that if you've got a deferred annuity, you've got two stretch choices. One is 5-year liquidation, and the second choice is distributions based on the beneficiary's life expectancy. And the key question is for stretch, when a trust is the beneficiary, is the trustee of the trust locked into the 5-year liquidation rule, just like an estate would be if it were the beneficiary, because there's no real person as the beneficiary? That's the key question. Are we locked into 5 years, or do we have the ability to stretch based on somebody's life expectancy? And that's what we're trying to figure out. Now, in the inherited IRA realm, we have a whole body of regulations that were before the Secure Act that created this whole idea of a look-through trust. And in the inherited IRA or inherited qualified account realm, if a trust was valid under state law, if the trust was irrevocable or became irrevocable at the IRA owner's death, if the beneficiaries were real people and could be identified, right? There weren't any companies or charities as beneficiaries. And if the trustee could produce a list of the beneficiaries to the carrier, or produce a copy of the trust by October 31st of the year following death, then if all those conditions were met, it was possible to stretch based on the age of the oldest trust beneficiary. Now, I stressed that this was pre-secure qualified account analysis. All of this stuff was the result of regulations that were in place prior to the Secure Act being passed. And the kicker is that for inherited non-qualified annuities, we don't have the same body of law that we do for inherited IRAs. And so the question was, prior to the Secure Act, could we apply the logic for an inherited IRAs, the logic of look-through trusts, to situations where a trust is the beneficiary of a non-qualified annuity? And we didn't know. We didn't know for sure. And that was part of the problem. And so there are plenty of uncertainties, that being one of them. Other uncertainties are we're now in a post-Secure Act world. Is that pre-Secure Act logic still valid now that we've got new rules with regard to inherited IRAs about stretch? Well, we don't know the answer to that. Seems like it should still apply, but the IRS hasn't said so explicitly. As I said earlier, look-through trust is an inherited IRA concept, not an inherited NQDA concept, so we don't know whether the logic can be ported. We're waiting for regulations that may clarify things for inherited IRAs after Secure, but we don't necessarily expect those regulations to say anything about inherited non-qualified annuities. So I'm not sure that those regulations will help us deal with the uncertainties where a trust is the beneficiary of an inherited NQDA. Now, to make things more complicated in the real world, at least a couple of carriers do allow for look-through analysis where a trust is the beneficiary of an inherited NQDA. That is that if the trust is valid under state law, we've got real people as beneficiaries, the trust is irrevocable at death, and all the beneficiaries are identifiable. Under those circumstances where a trust is the beneficiary of the NQDA, those carriers, and there are a couple that I know of, will allow for stretch based on the oldest beneficiary of the trust. Most of the carriers that we've dealt with don't allow for that. They force 5-year liquidation where a trust is the beneficiary. Which carrier is right, we don't know. Just because the carriers do permit stretch based on the age of the oldest trust beneficiary doesn't mean that the IRS will agree. And we're not quite sure what'll happen if the IRS disagrees at some point in the future where somebody has followed that path. Anyway, those are the uncertainties. If you've got a client who has a trust as beneficiary of an NQDA, and the current carrier won't allow for stretch based on the age of the oldest trust beneficiary, one of the things that will be considered is a possible 1035 exchange to change the carrier to a carrier that will do look-through trust stretch on an inherited NQDA where the trust is the beneficiary. There's a 2013 private letter ruling that allowed for a Section 1035 exchange of an inherited NQDA, but not all carriers, will allow that path, and we'll talk about that more in just a second. What is it that we're recommending that people do where a client is considering naming a trust as beneficiary of a non-qualified annuity? Well, this is really a review of what we've already talked about. A client is going to choose to name individual beneficiary or beneficiaries where stretch is really important, control is less important, and a very certain result is important to the client. If all those boxes are ticked, the client is going to almost always name an individual beneficiary rather than a trust, and that's the way that we should advise them if they're asking for our opinion. Where the client wants to exercise control after death or wants to protect family members after death, if that's the most overriding consideration, you're going to name a trust the beneficiary, and you're going to deal with uncertainty over stretch or be fine with the idea that 5-year liquidation is going to be required by the carrier issuing the contract. That's how the decision is going to be made on the front end. Well, what happens if we've got a trust as beneficiary of an NQDA and it's after death and the family's asking us for advice about what to do? Well, I think if we're trying to do a complete job, I think we're going to ask the carrier whether or not they honor the possibility of look-through stretch when a trust is the beneficiary. Getting that information from the carrier is an important thing. If the carrier won't do look-through stretch on an inherited NQDA, I think we're going to consider doing a 1035 exchange from one carrier to another. I alluded to the fact that 1035 exchange of inherited NQDA was permitted in a private letter ruling from 2013. Those of you who are tax geeks like we are will understand that a private letter ruling is not tax authority. It's just kind of an indication of how the IRS looks at things, and only the person to whom the private letter ruling was issued can rely on it. That means that not every carrier will permit a 1035 exchange of an inherited non-qualified annuity. We've heard of some carriers that will not. What does that mean? Well, that means if you're dealing with either a sending carrier or a receiving carrier that will not allow for a tax-free exchange of an inherited non-qualified annuity, you're done. You can't do it because the IRS requires both sending and receiving carriers to cooperate in order to pull off a valid 1035 exchange. So certainly considering a 1035 exchange, if you're at a carrier with a trust beneficiary of the NQDA that will not do look-through stretch, considering a 1035 is in the cards. you got to ask the next question as to whether that carrier will send the money to a new carrier that will do look through stretch for the same account. And even where you can pull off look through stretch on an inherited NQDA, I think you got to tell the client that there's still some risk the IRS is going to intervene and say that look through stretch is not available for trust inherited NQDA, because they haven't explicitly said that it is. And so you want somebody on the client's team, you want the client to have a tax professional, you want to warn them about that to serve them better and also to cover yourself from the potential liability exposure. So I think that's practical advice about how to handle things after a client's death where trust is the beneficiary of an NQDA. So to wrap it up, where trust is the beneficiary of a non-qualified annuity, 5-year liquidation may be the only safe choice. We looked at the tax code that says that. Sometimes control is more important than stretch. And so even if you understand that you may be locked into the 5-year option after death, because control is more important than tax timing or tax considerations, still naming the trust may be the right thing to do. Other options may be available. Be sure to understand, what your client intends, think through all the options, to warn them about potential risks, and do your best to serve them as well as you can. And from my perspective, that's it. If you have any questions, feel welcome to contact us. And at this point, I'm going to turn the program back over to Amber to wrap us up. Amber?
Thank you for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Feel welcome to join us for the next webinar on the first Wednesday of next month, which will be March 2nd at this same time. Next month's webinar will be titled Hidden Details in the New Minimum Distribution Tables. You can also find an archive of past webinars on our YouTube channel, Advanced Underwriting Consultants. Please subscribe to our channel. It helps us to keep making free webinar content. Today's presentation will be posted on our YouTube channel by the end of this week. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again and best wishes for continued success.